You're listening to The Rule of Law, the educational podcast sponsored by Allrise, where we focus on the intersection of law, technology, and storytelling. And now, here's your host, Lauren Round.
Welcome to Rule of Law. In today's episode, we sit down with Stephanie Wilkins, Director of Content at Legaltech Hub. We discuss whether AI prompts and content are discoverable in litigation, when using AI may break attorney-client privilege, and what attorneys should do to ensure they are using AI responsibly. Stephanie, welcome to the podcast. Where are you recording from?
Thank you for having me. I'm in Brooklyn, New York today.
Well, welcome. We always start the show with an icebreaker, just a little softball to get to know you a bit. So your question is, as a child, where was your favorite place to vacation or visit?
My grandparents' house. I never really had babysitters growing up. My only babysitters were my grandparents, and I had my first little suitcase, and it was my only time away from home, and for the most part, and just staying the night at my grandparents' house felt so special.
Amazing. That's becoming more rare, the sort of multi-generational setup for kids. So that's awesome. Well, we have a lot to get to today, but before we kind of dive into it, if you wouldn't mind just by starting telling us a little bit about you, your background, and maybe what you're currently working on at Legaltech Hub.
Sure. I'm Stephanie Wilkins. As you said, I am the Director of Content at Legaltech Hub, where I cover all things legal technology in the space, whether it's issues for vendors or for buyers and who are law firms and in-house legal departments mostly, pretty much anything that comes up in the legal tech space. Right before this, I joined LTH from ALM, where I was the editor-in-chief of Legal Tech News, covering pretty much the same beat. I started that job about 2 months before ChatGPT came out into the world. So that was a little bit of a trial by fire, and just dove in covering AI from that point on, which has been great. And there is no shortage of things to write about. For the rest of my background, I am a lawyer by training. I went to law school, came out and practiced in big law in general commercial litigation for about 8 years before retiring and thinking I would do nothing in law. But after a year of a break and a breather, I got back into it through the writing side. And I did that as a freelancer for at least a decade, going into legal technology without necessarily planning to, but found myself there over a decade later. And here I am now. And yeah, in terms of what we're covering, obviously it's a lot of AI. It's not the only thing, but it's hard to talk about anything technology without AI coming into the conversation these days. So yeah, just a lot of that. Everything people want to know about legal technology and trying to translate legalese and tech speak and have them talk to each other.
Absolutely. And that's actually a perfect segue into our first question. We're going to get to some specific AI topics today, but I wanted to start with a more general question. And in our line of work, there tends to be a lot of predictions made, particularly now at the beginning of the year, about what's next for the industry, etc. And one of your predictions was that in 2025, we'll no longer see AI in every session title of every conference because it'll just be kind of a given that everyone is thinking about it and using it. Can you tell us a little bit more about what informed that prediction and whether you're seeing that already?
Yeah, in fairness, as a disclaimer, I knew that was an ambitious prediction when I made it. I was probably a little bit more hopeful that might be a little bit more accurate for 2026. But I was saying that in 2024 because in 2023, when AI took over everything, it was all everyone could talk about it. Whether or not it was legitimate, it was just a buzzword put in anywhere it could be thrown in. And then through the course of that year and the course of 2024, the conversation has thankfully very much matured. People are on a wide range of their understanding, but the conversations around AI have definitely matured and are looking at more concrete uses and less hype. So it was my hope when I made that prediction that we wouldn't have to mention AI all the time, sort of similar to how we used to talk about cloud all the time by saying cloud. And now we very rarely hear cloud in a session title anymore, or if we do, it's a very specific one because cloud is just table stakes at this point. And I think eventually we will get there with AI. And as I said, maybe that was a more hopeful prediction of how soon we'd get there. So not 2025, but I still think we will get there.
Well, those are always the best predictions, right? The most ambitious ones. So nothing to hold against you there. So let's move to some specifics. Like we just said, everyone is still talking about AI, and that's for very good reason. But there are a couple of topics out there that I don't think a lot of people have weighed in on yet. And one of those you've recently written on is the discoverability of Gen AI prompts. So could you just sum up this issue for us at a high level and kind of explain this discoverability question that's out there?
Yeah, for sure. This is an issue that I don't think people are thinking about enough. I've started to hear little bits of conversation surfacing around it, but usually when it comes up, you see a light bulb go off, and it's not something people have been covering much, so I've been trying to dive into it. Generally, the idea is when you think of e-discovery and AI, most people are focusing on how AI is being built into e-discovery tools and changing e-discovery workflows, document review processes, all of that sort of thing. What people aren't looking at necessarily is how the way that lawyers are using AI or other legal professionals are using AI, that use itself may be discoverable. And by that, I mean, anytime you use an AI tool, you're generating data, whether it's the prompt you put into the AI tool or the data that it puts out in terms of whether you are doing an article, a brief, a draft, an outline, a timeline. All of that is data. And when you think about how e-discovery works, e-discovery document production requests in general are very broad, covering any and all information. It says documents, but we all at this point understand that documents means all data. It's defined that way. So any and all data potentially relating to a series of issues that are identified in the case. And if legal professionals are using AI as part of their work, which they routinely are more and more increasingly these days, you have to start thinking about whether that AI data falls under that. Arguably, it does. We can get into whether or not there are privilege protections or how that data might be handled, but it's definitely a thing that people are not thinking about yet. The same way, a few years ago, e-discovery professionals had to figure out how to deal with Slack data or data from ephemeral messaging apps. It was a whole new rubric that they mastered. E-discovery professionals are masters at new data types, right? But this is a whole new area of data being produced that is arguably can be related to litigations down the road, and people need to be thinking about how they're using AI, what data they're creating, if they're preserving it and retaining it, if it gets requested, what do they do? Do you even have access to it? So it's a whole new topic. I don't have the answer to all of those questions yet because none of it's been decided, but it's a thing I've been trying to really put on people's radar because I do think it's one of the next big issues that needs to be determined either way in the discovery space.
Absolutely. So there's a lot there. I want to drill down into a couple of the things that you just said, starting with you point out there's two sides to the discoverability question, the prompts that lawyers are putting in to generate new content and the generated content itself. So kind of walk us through your thoughts about how we should be thinking about the difference between those and how they might be covered in a discovery request.
Sure. I'll start with the second kind first because I think it's easier for people to think about when you're generating something with AI, say as a brief. Just pick any length of text, usually it is. It can be an image, it could be a chart, but whatever output you're creating from Gen AI, that feels more like traditional work product or something you would make. So people don't have as much of a problem thinking of that as maybe information or a document, if you want to call it data, that could be discoverable. It feels somewhat tangible. It feels normal. And often it's substantive, so if you do a piece of work that is related to the matter of your case, you could foreseeably be like, oh yeah, I drafted this whole memo with AI. It would be discoverable as if I had drafted a memo without AI. The other side that people have a harder time wrapping their heads around sometimes is the prompts that are going into the AI itself, because it's easy to think of a prompt as just, a few words or maybe a sentence, then you move on. But in reality, anyone who's played around with AI a lot knows that getting your optimal output from AI often requires a lot more than just a sentence. Some of these prompts can be paragraphs or even pages long, and they take a lot of iteration to get to the final that gets you the result you want. So that's a lot of work, and that's a lot of information contained in that prompt, and it might contain a lot of insights about your thoughts on the case, whether like what facts you think might be important to the case, what issues you want to focus on, what people you want to focus on. So there's a lot of data in that prompt itself, that people tend to forget about because once they put it in and they get the output, all they care about is the output. That's the reason they're using the AI in the first place. So not thinking about what you put in, even though there is a large amount of information and substance and work put into that prompt, that's what really is where I want to get people focused on, because there's a lot there and people might start asking for those prompts and want to see what it is you're putting into AI.
Yeah, for sure. Something to think about. So the natural question from there is the privilege and work product protection question. So lawyers will say, everything I did with these AI tools was done maybe in anticipation of litigation, so I'm not going to have to produce this. But you've written about sort of how AI becomes more heavily relied upon, as you alluded to earlier. It really falls outside of the realm of preparation for litigation. So can you walk us through that line of thinking a little bit and why privilege and work product protection isn't going to work for everything here?
Yeah, definitely. For some things, it's certainly a strong argument. If you are legitimately using these tools in anticipation of litigation, just like any other work you're doing, any other tools you're using, there's a strong argument that falls under work product privilege or work product protection. But more and more attorneys are finding AI usage valuable in almost every aspect of their work. I mean, one of the first areas where we started seeing a lot of traction with AI was in contracting, whether it's redlining or drafting. And that's, I was a litigator, I was not a transactional lawyer, but people in transactional practice, they're not entering into deals in anticipation of litigation, right? Like that's the work they're doing. So it's the more you use it outside of the realm of specifically handling a litigation matter, there's so much AI data being created. And you can't argue you can argue. I don't think you would succeed in arguing that is work product protection, because none of that work, a vast majority of work that lawyers and legal professionals do, is not done in anticipation of litigation. And the more they get their hands on AI tools and create this data, the less likely you can claim that privilege over it.
Okay. And there's also, in that same vein, some conversation about whether using these AI tools, particularly with prompts, breaks confidentiality, because there's some agreements that say, there could be employees of the LLM that are going to be looking at the prompts. So do you think there's any weight to that using these tools could actually break privilege?
Yeah, I definitely think there is some weight to it. I mean, the attorney-client privilege question is a tricky one, because on the one hand, if you're trying to claim it over your use with AI, this is not decided, but everyone is leaning towards the notion that these are not communications, so they wouldn't fall under attorney-client privilege. And even if they were, it's not between an attorney and a client, it's between a human and a robot. But that said, aside from you claiming privilege on it, you could also be breaking privilege, because say you are my client and I am your attorney, and you are telling me things that are only supposed to be between us. And then I go take some of that information and put it into an AI tool to help with my work. I need to know where that data is going, because these terms and conditions for a lot of these tools are very, very, very long. And we've seen plenty of instances where people don't read them. And this is actual legitimate legal tech tools, not something like ChatGPT. Just don't ever put any legal work into ChatGPT. That's my main disclaimer. But so if there is somebody on the other end of, tool company X that has the potential of reviewing the information you put in, storing it, but even not storing it, reviewing it, that's another set of eyes on this information that was meant to stay between you and me as attorney and client. And that right there, this has not been tried and tested yet, but there is a strong argument that you could be potentially breaking privilege right there. And then in terms of confidentiality or sensitive information, even if it's not a privilege question, you don't know where that's going. There was an infamous case probably a year and a half ago where a Samsung employee, using, I don't know if it was ChatGPT, but it was a public-facing tool, put proprietary code into it, and it went out to the world. So, that's not good, whether it's privilege, whether it's confidentiality, sensitive material. Lawyers have all of that stuff, and you don't want to get it getting out there in the world. So think of putting it in an AI tool as putting it to another human, unless you really, really know for sure that it's not.
Yeah, for sure. And I think that is what's leading us to see more and more companies blocking these tools, or I've even seen companies have sort of warnings or blocks when you go to paste information in there. So they'll let you type it, not paste, but then that leads to all these shadow AI problems, which we could have a whole nother conversation about, but that's even more dangerous than using traditional tools. So a lot of questions in there too.
No, you're definitely right. The shadow IT problem, which has been around for a long time, has definitely gotten reinvigorated with IT. I mean, some people are even trying to give it fancy names like bring your own or bring your own AI, and I'm like, that's just shadow IT still. So
Yeah, absolutely. So ultimately, it seems like this question is going to have to be settled through the courts. And we're very early on in litigating most of these questions, but do you have any sort of early signals as to where the courts might come down on these questions, or is it just anyone's guess at this point?
I'm not aware of any actual decisions on it, so I can't predict. I mean, I think the line I drew earlier about how substantive the information is, as opposed to if you have a very generic prompt that doesn't include anything, more likely to fall under it. Because I mean, discovery tends to be very broad, and the longer these prompts get, it's kind of hard to argue. But I'm not aware of any courts ruling on this yet. I think it's going to be one of the next big things they tackle, and the courts might have to change their rules. We've seen this in a lot of new technologies, whether it's the courts or the federal rules of evidence. They weren't written to account for anything like what we're using now. So, I mean, we might have to see some updates in those because these technologies aren't going away. If anything, they're only getting more powerful, more plentiful, and people are using them more. So it'll be an interesting ride, but I guess also better safe than sorry. So if you know you're generating this data now and I hope you have a data retention policy in general at your organization, you should be thinking about putting this kind of data under that retention policy sooner rather than later, because you don't want to be dealing with the issues when you're suddenly in litigation and staring down a production deadline.
Yeah, for sure. So on the topic you just mentioned, maybe we need to update the rules of evidence or, we need to litigate this to the courts, but do you think there is an appetite from state bars or the ABA or changing laws to address these issues, or is there not really an appetite for that? Because by the time they decide on the new rules, we're going to be on to the next technology and we're going to be out of date again.
I think it's a little bit of both. I don't think we'll be on to the next technology and it's out of date yet, but I think they might think or hope that. I mean, I think there's definitely a lot of interest in this. There's a lot of talk about it, but any major systemic changes like that take a long time. There is generally a move by a lot of bar associations to require additional kinds of training. I mean, there's always been a attorney competency requirement to know how to use technology and how it's being used and to understand AI. But I think there's been a much bigger push. There's a lot of task forces across bar associations to really educate people specifically in AI and how it's used to hopefully address some of these issues before they become problems. So I'm seeing an uptick in that, and I wouldn't be surprised if you see some CLE changes too. Like there are certain states like New York, where I am, has a cybersecurity requirement right now. We could one day see something around AI and emerging technologies as well. In terms of amending the federal rules or court rules, I mean, I think that takes a lot of work and a lot of time. But we've seen a lot of, judges issue standing orders about the use of AI kind of in the opposite direction. And people have mixed opinions on this. I'll try to stay neutral about it. But, there was initially, when we were getting hallucinated case citations submitted to courts and briefs, there was a lot of initial reaction by some judges to you have to disclose all use of AI in anything. And I mean, that may on surface sound okay, but we're not even talking generative AI in that statement. AI isn't everything, and people don't necessarily even know AI is and what they're using. I mean, do you have to just disclose Grammarly if you're using that? I mean, that's AI. We haven't had to tell judges if we used, AI-powered Westlaw searches before. So, I mean, we've seen initial reactions like that have had varying degrees of success or longevity, but I think it signals to me that there is an interest. Everybody knows that this is not I don't want to say it's a problem because I'm very pro AI, but this is definitely an issue that needs to be addressed. It can't be addressed under existing rules and regulations and just the rubric of how we've ever handled things before. And it's not going away. It's not a passing fad, even if, some people probably hope it was. But we're going to have to figure out how to address it. And the big question is how, and if we can get any sort of consensus around it rather than a piecemeal approach that leaves people more confused.
Let's pause for a moment to hear a word from our sponsor, All Rise.
Deploying new software technology can disrupt familiar workflows and processes, and it often comes with a steep learning curve for the employees in your law firm. We get it, but it doesn't have to be that way. All Rise is a comprehensive law practice management system deeply integrated with the Microsoft tools and technology you're already familiar with. So no steep learning curve is required. And because All Rise is a modular software platform, you can deploy only the specific capabilities you need when you need them. Your choice. If you want to streamline internal operations, boost staff productivity, and deliver superior client service, then take a close look at the AI-powered All Rise platform. It's time to experience software innovation that enables practice excellence. Learn more at allrise.ai.
So, I think a lot of attorneys might not know exactly what to do at this point while these questions are still up in the air, but at least with respect to, in the meantime, like things like legal hold or preservation of records, you mentioned this a bit before, what should attorneys be doing right now with respect to those things? This is not legal advice, but just like how would you think about legal holds and preserving records in the meantime?
Yeah. If you as an individual attorney or legal professional have a question, ask someone first of all. And then just always, my two adages really are think before you prompt and better safe than sorry. So I think a lot of this has to fall more organizationally on law firms or legal departments to tell their people, educate their people about these issues, that what they're putting in might be used. And also pretty much every company has some policy around data at this point. They need to make it clear internally how they are applying that to electronic data like AI data, but then also convey that to people too, so that they know what they're doing, where it's going, who might see it, because it shouldn't ever fall on the individual practitioner to decide whether or not to preserve something or not. That's a recipe for disaster, right? Everything should be preserved for a set amount of time that somebody beyond me as the individual lawyer decides what that is. I shouldn't have to interrupt my daily workflows on, am I saving this somewhere? Am I whatever? That should be a broader issue. But so unless you're the person involved in making these policies and enforcing them, I would say you as an individual attorney, again, treat your AI usage, what you're putting into it or getting out of it, the same way you treat anything else you do in the course of your job. They always used to say, if you're going to write a memo, pretend it might be on a billboard in Times Square somewhere. Same thing with what you prompt your AI to do. And it may never get there. Great. But in the meantime, you've followed best practices and you're probably getting better outcomes and better serving your clients for having followed those practices, even if it doesn't end up becoming discoverable.
That is always sound advice. Act like whatever you put down in writing is going to end up in the press, because it's happened to plenty of people. So you never know what's going to happen to you. So something else, this is sort of a little off topic, but something that you've written about is this idea of prompt libraries. Mm-hmm. And I don't think that's something that a lot of people know about or have heard of. So could you explain kind of what a prompt library is for AI and what its role might be in all of this?
Yeah, absolutely. So prompt libraries are a thing that are gaining some traction, mostly in large law firms with, pretty robust knowledge management departments. But the idea of it is essentially like a lot of firms or organizations will have a clause library when they're doing contracts. This is our set of clauses we like to use in contracts, our preferred language. It's a similar thing with AI prompts. As we said earlier, prompts usually are not just a sentence. They're usually a paragraph long. They can be pages long. It's gone through a lot of iterations and trial error to get that perfect prompt, to get the ideal output. And so what a lot of organizations are doing are taking that ideal prompt, sort of anonymizing it. So, you put in, instead of saying, I'm a candle making company, it would be like insert here company, And so you sort of templatize the prompt. And so that people can use it people who are doing similar work just with different fact scenarios can take those prompts, put them in, but put in the placeholders or fill them in with the relevant issues to their case, and then generate the same sort of output. So you have uniform output, which is great for legal practice in general, but it also gets rid of that time of reinventing the wheel and, that hour it might take to get that perfect prompt in place. So it's becoming a new sort of precedent internally in knowledge management where organizations will have these prompt libraries that help people get past that stage of getting that good output. And the way this comes into play is, again, none of this has been tested yet, but if you have those prompt libraries in place, you're cutting down on the likelihood that people are doing rogue prompting or putting in information they shouldn't. There will still be cases that are not covered by prompt libraries for sure. But if you can eliminate a lot of that trial and error, especially as we're seeing more and more people use AI who might not be comfortable with prompting or used to getting the right response, that can really help prevent people from putting in information that might one day be seen by somebody else, whether it's by breaking privilege or being produced. And then also, my inclination was that if you have a bunch of templatized prompts, those wouldn't necessarily fall under discovery requests because there's no case-specific information in them. You would probably only have to produce the one that was specifically used in your matter. And again, that's been very controlled, and there's the idea of what you've put in there, meaning to get a specific output. Again, I'm sure people don't want any of these to be seen, so there'll be arguments for protecting them. And the same work product considerations we talked about before would apply, but it's a much more systematized way to do it without you know what to expect more if you have a better set of things that are being put in the first place. And those prompt libraries could also be, in terms of a data governance and data retention situation, they're right there. They're easier to, they're there. It's easy to maintain those. And if there's one you decide isn't good anymore and it's a template, I don't really see any problem in deleting that because, it's a template you don't use anymore. There's not really there's no nefarious drive behind that.
And I think people do, I see this, underestimate the learning curve with prompts. Everyone's kind of dabbling with all of these tools. But as we all know, the content output is only good as the prompts that you put in. And so having those libraries, I think, can be double beneficial, from the confidentiality and risk management standpoint, and then also from just making sure people are actually getting an efficiency benefit out of using those tools. So, all right, well, I want to close with kind of a where do we go from here question. You already mentioned some really good actionable items, having policies around AI, maybe implementing some of these templates, treating the use of AI tools as you would any other work product. Any other really actionable tips that attorneys listening right now can sort of take and run with while these questions are still up in the air?
Yeah, just generally understand what your tools are doing, where your data is going. That's a bigger issue for sort of, I guess, your IT teams, your KM teams, but who will be the ones that are choosing these tools. And if you're choosing a vendor, know what their data retention policies are, because some of these tools might have an internal policy where they save your prompts forever and you don't necessarily want or need that. But just always know what you're using, how your data is being used, just like any other data. We all are aware by now that data can be a minefield, right? And use tools that your organization has said you can use. I know you might find something cool out there, and you can always ask them if they want to implement it in the firm and allow it, but you can really get yourself in trouble doing shadow IT, bringing your own AI, BYO AI, apparently. So just be smart. If it feels like magic, it's probably not. If it feels like maybe you shouldn't be doing it, you probably shouldn't, but just be smart about it. Just better safe than sorry is always the right way to go, especially with AI as we're figuring out the power of these tools and the data implications.
Yeah. No, this is absolutely a case of you definitely want to ask for permission, not forgiveness. So yeah. we will see that play out. Well, Stephanie, thank you so much for being here. Everyone listening, go check out Stephanie's Tuesday column and weekly watch list for Legaltech Hub. And Stephanie, what's the best way for listeners to find you and follow you?
Oh, yeah, great. That would be great. I'm on LinkedIn, Stephanie Wilkins. I think it's just Stephanie Wilkins. But yes, you can also follow Legal Technology Hub. I post some things there as well. And my email is simple. It's just stephanie@legaltechnologyhub.com if you want to reach me. If you have press announcements or anything to cover, we have a generic press email as well, press@legaltechnologyhub.
Perfect. Thank you, Stephanie.
Thanks for having me.
Thanks for listening, and join us again for another Rule of Law podcast from All Rise.